The Honorables, the presiding judge, and the judges of the Court of Appeals of the State of North Carolina. Oyez, oyez, oyez. The Court of Appeals is now in session. God save this state and this honorable court. Be seated.
Good morning. Welcome to the North Carolina Court of Appeals. Thank you to Duke Law School for hosting this special session of court. I'm Judge Allegra Collins. To my right is Judge Toby Hampson. To my left is Judge April Wood. And to my Toby's right is Deputy Marshal Salou, who is both our clerk and our marshal today. So we thank him for our services. Today we've got two cases on the calendar. The first one is 23-1106 State v. Watlington. Second is 24523 Cedar Brook Residential Center versus North Carolina Department of Health and Human Services. After the first case, we will take a break. We won't recess, but we will take a break. We'll allow students to come in and out. We'll allow the attorneys to change, and then we will get started with the second argument. And after the second argument, we'll have a short session for questions and answers for students. All right? So our first case, State v. Watlington. Counsel, are you ready?
Yes,
I'm going to proceed.
Good morning, may it please the court. My name is Warren Hinson. I represent Miranda Watlington. I intend to use my full 15 minutes for my client at this point, and Mr. Schatz, who represents the co-defendant, Ms. Felton, will allocate his time to include rebuttal. I intend to principally address two issues from my client's brief, the felony murder issue and the unit of prosecution issue for the hit and run, but I invite the court's questions on any of the issues. Miranda Watlington is wrongfully serving a life sentence for felony murder that is invalid as a matter of law. Our Supreme Court and prior panels of this court have made clear that assault with a deadly weapon inflicting serious injury cannot serve as a predicate felony for felony murder where there's evidence of the defendant's impairment and the use of a motor vehicle is the deadly weapon in question. If this court were to hold otherwise, it would be the first panel in our state to authorizing a felony murder conviction and corresponding life sentence in this particular set of circumstances. To be clear, I am not saying that assault with a deadly weapon inflicting serious injury can never serve as the factual predicate or the predicate felony for felony murder. But in this specific set of circumstances, where there is evidence of the defendant's impairment and where the use of a motor vehicle as a deadly weapon, case law has shown and established uniformly that felony murder cannot be based on assault with a deadly weapon inflicting serious injury. The state conceded this exact point in State versus Woodard, and the Court of Appeals vacated the first-degree murder conviction in that case and remanded for a new trial. The same was done in State versus Jones and State versus Blackwell.
Don't the facts of this case point to more of a specific intent here than in any of those cases where you have a scenario where your client backed up over the victims, crashed into another car, stopped, and then ran right back over the victims before fleeing the scene? Is that not more evidence of specific intent rather than culpable negligence than we've seen in the other cases before?
I think the key thing to look at with respect to whether there was specific intent was that the jury spoke loud and clear and rejected that Ms. Watlington acted with specific intent. They acquitted her of every specific intent offense that she was charged with and convicted her on lesser offenses. So I think that was a question for the jury, and the jury resolved it loud and clear. They did not think, because maybe it was the evidence of impairment, maybe it was the fact that there was a melee that ensued that affected her state of mind, but that they believed there was no specific intent to kill by Ms. Watlington.
Wasn't the only real evidence of impairment the fact that your client testified that she'd been out drinking all night and that she was impaired? But otherwise, we don't have anything from the officers or any other independent evidence of impairment.
So Ms. Watlington did not testify in the trial. However, the officers who were at the police station who interviewed her testified that she was so intoxicated that they were concerned about the admissibilities of her statements, that they did not want to interview her, that after she changed clothes, that she continued to smell like alcohol. There were other late witness testimony about her appearing intoxicated. So I think there was evidence of her impairment.
They didn't charge her with driving while impaired.
They did, and they dismissed it because they wanted to proceed on more serious charges.
Do you concede that there was evidence of intent to commit the assault?
I think that there is not specific intent to kill. We know that from the jury's verdict.
Yeah, I'm asking you, was there evidence of a specific intent to commit the assault?
I think there could be, and this goes back to Jones, either an actual intent to inflict an injury, or there could be an actual intent that could be implied from culpable or criminal negligence.
So do you think there's actual intent here based on the video that we all watched? Is there an actual intent to commit the assault with intent that caused the serious injury?
There is an actual intent to operate the motor vehicle that was
In a way that ran over people?
I think that the evidence does show that there was some intentional action taken.
Okay, so
And I'm sorry.
yeah, so my question is, when we're talking about felony murder and the underlying felony, is it the actual intent to commit the assault in this case? It's not the actual intent to commit murder in this case, correct, that we look at, but the intent to commit the assault that then is the underlying felony for felony murder.
Right. So Miss Watlington was charged on two different theories of first-degree murder: premeditated and deliberate, and then the felony murder. Acquitted on the premeditation, deliberate, and then for the felony murder, you do have to look to the intent of what is required for the underlying felony. Now, the rationale for why this particular felony, assault with a deadly weapon inflicting serious injury, can't serve as the predicate felony is because, as a matter of law, that particular felony can be committed by actual intent or criminal or culpable negligence.
Right, so let's turn to the trial court's instructions. And the trial court only instructed on actual intent to inflict injury, correct?
For the predicate
Assault with,
felony.
correct, right? So there wasn't any confusion by the jury as to whether they were looking at culpable or criminal negligence or actual intent, correct?
Yes,
So
but that
that's
goes
distinguished from Jones, correct, where that it could have been either.
and I think there is an issue, as we addressed in our second issue in our brief, that the jury should have been instructed in accordance with Jones that if the jury found that there was criminal or culpable negligence on the part of Ms. Watlington, that it should not return a guilty verdict on the felony murder.
So your argument then is that because there was evidence of criminal or culpable negligence, it should have been instructed on both, and then you can't have that be the predicate felony?
I think they have to. So the first issue, we're saying that it shouldn't serve as the predicate felony. It can't serve as the predicate felony.
But it can if there's an actual intent to commit the injury, correct? I think you conceded that in your brief, right?
So if we're reading Jones and Blackwell, which was a decision that came out from the Supreme Court the same day as Jones, and then Woodard from this panel following it in 2001, those cases just, I want to say, in the same set of circumstances where there's evidence of impairment and the use of a deadly weapon that is the motor vehicle, that they remand for a new trial on second degree. They say that the appropriate charge is second degree. There isn't a discussion, and that's because if you think that for felony murder based on assault with a deadly weapon inflicting serious injury, that you could have actual intent or implied intent, then that a life sentence shouldn't be permitted, or a first-degree murder conviction should not be permitted based on any element of implied intent that could be derived from the defendant's actions.
On the instructional issue, though, was there a request made for the jury instruction that you're now advocating for?
There was not, and we framed the issue as plain error in our brief because there was no specific request for that instruction, but the court can reach the issue and discuss that and make a decision if it finds that it was plain error. And we did argue in our brief that it did rise to the level of fundamental error simply because the jury clearly had concerns about the defendant's intentionality and specific intent. And if they had had all the tools to and information it needed to adjudicate whether or not felony murder was an appropriate verdict, given the Jones holding, that it might have reached a different outcome.
But is that not something that the trial court could have remedied as a matter of law, even upon the jury verdict, since this is, as you argue it, as an issue of law, not of fact?
And the trial court did not remedy it by arrest. You mean by like
arresting judgment or
yeah. They did not. They could have. It wasn't brought to the court's attention through a JNOV or anything, which is why we've framed it as a issue of sentencing to her, like a life sentence based on this particular judgment.
Can we turn to the multiple counts of hit and run? I'd like to hear what you have to say about that.
Sure. So Ms. Watlington was convicted of 5 counts of hit and run. And our argument is that the unit of prosecution for this particular statute, GS 20-166, is ambiguous. And that it is unclear, it's ambiguous as to how many counts can you be convicted of for leaving a single scene or a single crash. And so we would argue, our argument is that leaving the scene of a single crash event constitutes one act of leaving the scene that gives rise to one count of, or one charge of leaving the scene, regardless of the number of victims that are injured in the crash. Other states, including Pennsylvania, Virginia, West Virginia, California, New Jersey, and Massachusetts, among others, have all ruled in the same way, have interpreted their hit and run statute to say, you know, the gist of the offense is to facilitate law enforcement investigations into the crash, for the person to remain at the scene, figure out what happened, you know, and leaving the scene is the, you know, the actus reus of the offense.
So your argument here is that the term "to any person" is ambiguous.
Right.
And I guess my question is how is it ambiguous, knowing that other cases and other courts with similar statutes have found it to be ambiguous? But my question is here, it doesn't say any person or persons, and it doesn't say any people. It doesn't say any persons. It seems to me it says any person. It's one person, so one person, one accident.
So the emphasis, I think, is on the word any. In our courts, the appellate courts, this court, other panels have said any can refer to the singular or a plural. And for example, when you talk about possession of a firearm, even if the statute doesn't say firearms, it could mean singular or multiple firearms. So if you have, for example, possession of a firearm by felon or possession of firearm on educational property, and you have, you know, a person who has multiple firearms, then our courts have said, well, it only authorizes one count of possessing a firearm, regardless of the number of firearms, you know, that they had at that time. So I would say the same thing is true here. Independent of whether it says persons or person, the emphasis being on any, meaning possibly singular or plural, it only allows for for one, when you invoke the rule of lenity, to read it in favor of lenity. So
you've quoted Connolly and Smith, I think, is supporting your argument. Is that correct?
yes.
Are there any arguments to the contrary? Any cases that have come down in the criminal context that have said any is not ambiguous and it means one?
I believe I have Conley, Wiggins, and Smith that I've cited. Off the top of my head, I cannot recall.
Okay, so no cases have come down to the contrary that you can, off the top of your head, that you know.
Off the top of my head, I don't want to give the court false information.
You're good.
Yeah.
Okay.
Let me check.
Well, the state argues that State v. Lawrence says the defendant may be found guilty of multiple crimes arising from the same conduct as long as each crime requires proof of an additional or separate act. And one of the things they rely on here is that there were 5 different victims, and the state had to prove serious injury to each of the 5 separate people. So what is your...
I think that Lawrence concerned a double jeopardy argument, if I remember correctly. And it's not a double jeopardy issue. Proving separate elements for separate offenses would fall under that category. I think our argument is it's not a victim-oriented offense. It's not dependent on which victims are injured. The act is leaving the scene, failing to stay at the scene. And if it's one scene and you leave, it's one count of leaving that scene by not staying and facilitating an investigation or helping law enforcement. So I'm going to turn it over to Mike.
Thank you. You may proceed.
May it please the court. I'm Assistant Appellate Defender Dan Schatz, and I appear today on behalf of Ms. Felton. I would like to reserve 4 minutes of my time for rebuttal, and we have very little time, so I'm going to try and get in as much as I can. I'm going to start by just talking about whether Ms. Felton acted as an accessory at all and get into some of the unit of prosecution issues. But I welcome any questions the court has. Best to interrupt me now if you have something, because I might not get to it otherwise. So Ms. Felton's alleged crimes start after Ms. Watlington's, whatever she did occur, whatever they are, that's when Ms. Felton's crimes can start. Because the case law says accessory after the fact does not begin until after the principal felony has been committed. So when you watch that video and Ms. Watlington runs over the people, and then at the end Ms. Felton gets in the passenger seat, and Ms. Watlington drives off. At that point, Ms. Felton could not possibly have done anything yet to become an accessory after the fact to Ms. Watlington's felony, whatever they might be. And so then after that, we have very little evidence at all.
So just so I'm clear, she could not have been accessory after the fact to what she did when she drove over the victims?
What I'm saying is at the point in time when Ms. Felton gets in the car and they drive off, at that point, she could not have yet done anything to make herself an accessory after the fact. Because Ms. Watlington had just finished doing those things.
And that means that it's after the fact of those things. I think,
So that's when she could potentially start doing something that would make her an accessory after the fact.
getting in the car, correct?
Well, I don't think getting in the car itself in any way is an act that assists.
But I'm talking about the period of time at which we start.
Yes. So
Getting
once
in
she
the
gets
car.
in the car, but not for the hit and run offenses, but for the assault and the homicide offenses.
Your argument is there are 2 separate time periods. One is after the assaults,
Yes,
and then
and the other is after the hit and run. So the point is we don't have much evidence of what she did. You know, that's why I've argued in the brief, it's pure speculation that she did anything. You know, the state says she must have helped her conceal the car, but Ms. Watlington could have just as easily driven the car. It's 2 buildings away. So there's the gas station is like at the first intersection after you get off of I-40, and then there's a DoubleTree next to the gas station, and then there's this office building behind the DoubleTree. and that's where the vehicle was parked.
But just because she could just have easily done those things by herself doesn't absolve.
Well,
any
it doesn't
kind of-
conclusively mean that Ms. Felton didn't help her, but the state has to affirmatively prove that she did.
But this is in the posture of you're making this in the argument in the posture of a motion to dismiss.
Yes.
Which is maybe the one time we view the evidence most favorable to the state and draw all inferences from the evidence in favor of the state, correct?
Yes, but all reasonable inferences, and they have to come from the evidence. So the question would be, what specifically did Ms. Felton do to assist Ms. Watlington, and how does it demonstrate an intent? So the Potter case that's cited in the briefs makes clear that being an accessory after the fact is a specific intent offense. So the jury has to first infer that Ms. Felton did something that in fact could lend assistance to Ms. Watlington, and then that it has to be done with specific intent.
So what we have here is Ms. Felton getting into the car
Yes.
after the incident, the car or the vehicle being found just up the road by a loading dock. We have evidence of the two walking down the street, back down the street.
Yes, each of them walking down the
And
street.
Ms. Felton is found with the keys to the vehicle in her purse.
The keys to her car, yes, her SUV. And there's also, and I wanted, sort of the elephant in the room here is State's Exhibit 87, the officer's body-worn camera. And I want to be very clear about this. It's almost like a detective mystery where the reader has more clues than the detective in the story. So here, if the jury is the detective and the court is the reader, if you look at State's Exhibit 87, and it is part of the record, but I want to be clear, it is not part of the evidence that the court is judging the sufficiency of it. But I think what it does is it shines a light on the deficiencies in the state's proof. It kind of shows why we're correct that when we say, no, it's not inferences, it's speculation that she did anything, or that she had the intent to assist Ms. Watlington. And so the soundtrack to that officer's body-worn camera is really important here to highlight, what was going on, because what we learn is that Ms. Felton actually took the officers to the car. So what it highlights is the state didn't ever show how the officers located the vehicle. But this exhibit, if you play the part that after the state showed the jury, it shows that Ms. Felton led the officers, she tells them the keys are in my purse. The officer says, where's the car? She says, it's over there. The officer says, can you walk me to it? And they start walking off.
Ms. Watlington is not at the car, correct?
Ms. Watlington was there, so when you watch the video after the 19-second mark that the state stopped it, the officer runs past Ms. Felton. Ms. Watlington's a block behind her. That officer goes to Ms. Watlington. They bring her, along with other officers, they bring her back. By this point, Ms. Felton has walked up to the driveway to the DoubleTree, which is next door to the gas station, and they bring Ms. Watlington there, and you hear Ms. Felton. If you can drown out and filter out Ms. Watlington screaming at Ms. Felton to shut up, you'll hear Ms. Felton telling the officers, we were just attacked, it was a battle. Officer says something, and then she says, the keys are in my purse. Officer says, where's the car? She says, it's over there. The officer says, can you show me? Can you walk me? And they start walking off. And Ms. Watlington the officer who's got the body camera is with Ms. Watlington at that point, and they're all going in the same direction up the driveway of the DoubleTree towards where the vehicle is parked behind it. Then Ms. Watlington is still yelling at Ms. Felton, so some of the officers peel Ms. Watlington off and take her behind the gas station to where their squad car is parked on the perimeter. They don't want to walk her through the scene. And then if you listen to the officer's body-worn camera at, it's going to be 8:21 and 40 seconds on the clock on the video. You hear radio traffic. The vehicle has been located at 2211 Meadowview in front of the Boone building. And if you look at record page 222, the building that the car with the picture that shows the building is called the Boone Professional Building. Now, and so what we know is that Ms. Felton actually, she's leading the officers there, and within 2 minutes, they find the vehicle there. So the only reasonable inference is that Ms. Felton took the officers to the vehicle, and that demonstrates that she was not of the mindset of concealing the evidence, the vehicle, the keys. You know,
But some evidence of mindset, why is that not simply a jury question?
well, because again, I think it requires the jury to speculate. So the question would be, what did she do that assisted Ms. Watlington? How, you know?
Well, isn't there evidence, as we've already discussed, that your client watched Miss Watlington run over these people twice,
Sure.
got into the vehicle,
Yep.
and left with her instead of staying, rendering aid, calling law enforcement, or anything? She left the scene with Miss Watlington.
Sure.
So isn't that a question then for the jury?
Well, no, because not reporting, not failure to report cannot, the Didenhafer case, the Potter case, failure to report, you know, she didn't have an affirmative duty to assist or report. What she can't do is actively assist Ms. Watlington. And it's also not, it's not an acting in concert thing, because Ms. Watlington, of course, can't be an accessory after the fact to her own crimes. So it's got to be something, and the Didenhafer case makes it, it's got to be something affirmative that Ms. Felton did to actively assist Ms. Watlington. It can't just be, you know, like in an acting in concert situation, the silent acquiescence, you know, and silent support kind of situation. That just doesn't get the job done on accessory after the fact.
Can we go to accessory after the fact to all the crimes committed,
Sure.
or just one?
So again, the thing I want to say about this beyond what's in the brief. So if you look at the Didenhafer case, it says, and this is on page 400 of the Southeast 2nd pagination, it makes it clear that the gravamen is the assisting of the principal, not, you know, the person is being prosecuted and punished for assisting the principal, not for the harm done to the victim. So it's the gravamen of the offense is assisting a principal who has committed a felony. And if you go back to the Potter case, in the last two paragraphs, you know, we've cited it for the idea that failing to report doesn't make a person an accessory after the fact, but it also says some other things. It makes clear that accessory after the fact is a specific intent offense, that the action has to be done with the intention and for the purpose of assisting the principal. And then it also goes on, in the last two paragraphs of the opinion in Potter, it explains that the principal was properly charged under two different felony assault statutes. It was secret assault and assault with a deadly weapon inflicting serious injury. And then it says, and the indictment and the evidence were sufficient to show that the defendant, whose appeal it was, acted as an accessory to the felony committed by the principal. So even though they immediately acknowledged that the principal committed two felonies, they still described what the accessory did as assisting the principal, after, you know, being an accessory to the felony committed by the principal. So it's really the felonious conduct.
Does the number of victims matter?
No, I don't think so.
The number
I don't
of crimes
think
charged?
neither the number of victims, the number of felonies. It is, if you do one thing to be, and the verb in the statute is to become an accessory after the fact. And if you do something where you become an accessory after the fact and you assist a felon, that is, you have committed a crime of being an accessory after the fact. And I'm cutting into my rebuttal time, so if there are not further questions, I will yield to the statement.
Yep, thank you.
May it please the court, I'm Catherine Haythcock from the Attorney General's Office on behalf of the state. First, I'd like to get into the Watlington arguments. First, about whether assault with a deadly weapon inflicting serious injury can serve as the predicate felony under felony murder. And the state's position is that it can. Under General Statute 14-7A, any other felony committed or attempted with the use of a deadly weapon can be a predicate felony under 14-7. But it does require actual intent to commit the act that forms the basis of the first-degree murder charge. And in this case, there was actual intent to commit the assault. The jury and the trial court instructed the jury, if you find from the evidence beyond a reasonable doubt that defendant Watlington intentionally struck these 6 people and that while committing the assault, she killed Zanelle Tucker, it'd be your duty to return a verdict of guilty of felony murder. So they were properly instructed that to find assault with a deadly weapon inflicting serious injury, they had to find the actual intent to strike, and they did that here. Now, they did acquit on first-degree murder, premeditation, and deliberation, but they did find actual intent to commit the assault. So that did elevate this to felony murder and supported the conviction.
Can you address counsel's argument that there was evidence here of culpable negligence and the jury should have been instructed on that?
Well, here the evidence did not support submission of culpable negligence to the jury. There was no chemical analysis introduced, no testimony regarding what Ms. Watlington consumed and over what time period. The trial court pointed out that both defendants were walking around, able to keep balance. They went in and out of vehicles on numerous occasions. They opened and shut the door multiple times without problems. He also found that defendant Watlington was under control and in possession of her faculties. She picked defendant Felton's sweater off the ground and tried to keep defendant Felton from fighting. And the trial court also pointed out the law that evidence of mere intoxication is not enough to meet a defendant's burden of proof to support the instruction. She must produce substantial evidence which would support a conclusion by the judge that she was so intoxicated that she would not form a deliberate and premeditated intent to kill.
Well, we're not talking about an affirmative defense here of voluntary intoxication. We're talking about the fundamental elements of the offense itself, which could be, the serious injury offense could be supported by recklessness or culpable negligence, correct?
Right, but we just didn't have the evidence here of culpable negligence to support that. The defendant didn't testify. She didn't offer any evidence to support this.
But it's the defendant's burden? It's not her burden, right?
It's her burden to show that.
Not an affirmative defense. We're talking about a burden for a jury instruction.
It has to be supported by the evidence, Your Honor.
But it isn't defendant's burden to put that on. It's the state's burden to show that that's not the case, correct?
And the state did do that in this case, Your Honor.
We just want to make sure that you have the correct burden.
I'm sorry, I didn't mean to misspeak. Yes, that's correct. It's the state's burden. And also, the defendant did not object to this. There was never a request for a culpable negligence jury instruction in this case. So there was no plain error by the judge in failing to give that instruction that wasn't requested. The defendant points to cases like Jones, Blackwell, and Woodard to say that culpable negligence prevents this from being elevated to felony murder under assault with a deadly weapon. But in all of those cases, the death was an unintended consequence of the underlying felony. There was no specific intent to strike the victims like we have in this case, where we do have an actual intent to strike.
So each of those cases, I think your colleague would contend kind of do create somewhat of a bright line rule that because the offense could be founded upon culpable negligence, that necessarily forecloses with evidence of intoxication, that necessarily forecloses the felony murder conviction. How do you respond to that?
Well, assault with a deadly weapon inflicting serious injury can be based on either culpable negligence or actual intent to strike the victims. Now, if it's culpable negligence, that automatically excludes felony murder as being on the table. But where there is actual intent to strike, like we have in this case, it's not very common, but where that is the case, that does leave open the door for felony murder.
And what case would you point to for that proposition?
Well, that's in Jones. That's the holding of Jones that where there is actual intent that it can be based on felony murder. In the language of the statute itself, 14-7A. And moving on to the unit of prosecution argument for 20-166, our courts have never found General Statute 20-166 ambiguous.
Has that ever been squarely before us?
Pardon?
Has that question ever been squarely before us?
It has not ever been. This is a matter of first impression for this court, whether 20-166 authorizes one or multiple units of prosecution for hit and run inflicting serious injury. Now, the statute says that the driver of any vehicle who knows or reasonably should know that the vehicle is he or she is operating as involved in a crash and that the crash has resulted in serious bodily injury or death to any person shall immediately stop. And the state's position is that any is not ambiguous. It's followed by the word person in the singular. So it means one or many, each injury. The focus should be not on leaving one scene, but on leaving 6 people killed and hurt without medical attention.
How do you distinguish that then from Conley for any gun? And the determination was, it doesn't matter how many guns you have on you.
Conley was weapons on school property. And when you consider one gun on school property versus multiple guns, it's not necessarily obvious that multiple guns on school property would be more harmful than one, because one or multiple pose danger to school children. But here it's clear what the unit of harm is. Hurting 6 people is indisputably more harmful than hurting one person. And the gravity should scale with the number of people injured in the hit and run incident.
But don't you just flee one scene? Aren't we looking at what the intent of the statute is to punish? And you're being punished for the underlying felonies, correct?
Yes.
And here, the unit of your action is leaving one scene, correct?
It is. It's leaving one scene, but it's leaving many people injured. And that's what the state contends the focus should be on the number of people injured, focusing on that singular person in the language of the statute, any person, any and all people. Here's Annell Tucker, Latika Tucker, Danetta Evans, Billy Travis, and Kaylin Birch. All were very seriously injured or killed. And I don't even know how that would be charged. We have 1 person dead. We have 3 that are seriously injured. We have 1 that was just injured. How would that be charged? Hit and run. If you pick the one that's inflicting serious injury, or do you do the death? I mean, they're all very different. You have different victims with different injuries that should all be charged accordingly by the district attorney.
Were they all charged as the specific intent of hitting those people? They were charged with the
They
assault.
were charged with the assault, Your Honor, but the state's position is that the hit and run should follow that same pattern for each person based on the language of the statute. This case is also different from Smith, the dissemination of porn cases that found the word any ambiguous, because buying or selling multiple pornographic magazines is not obviously more harmful than just buying one, and it doesn't necessarily scale like the clear facts in this case. It's the state's position that the legislature intended to punish a defendant who runs over multiple victims and leaves them for dead in the parking lot.
But after Connolly and Smith, the legislature could have changed the verbiage of this statute to ensure that it didn't mimic those, correct? And they didn't?
Those are different statutes, but yes, Your Honor, they could have changed the wording of those statutes for dissemination of porn and weapons on school.
No, I'm talking about this. They could have changed this statute to ensure that it was clear that we aren't talking about one scene, but we're talking about leaving multiple victims.
They
right?
could have, Your Honor, but this is an issue of first impression, so I haven't had the opportunity to really consider the ramifications of this statute.
True, but they had the education from Connolly and Smith to understand how our courts see any gun, any obscene material, correct?
They do, but again, the state's position is that this scales very differently when you're talking about dissemination of porn and weapons on school property, as opposed to 6 different people who were killed or seriously injured.
So the dissent in Connolly argues that there is an identifiable purpose to punish more severely multiple guns. So the identifiable purpose in this statute here to punish more severely for multiple victims is simply that you have multiple victims.
Yes, Your Honor. If it's held to be one unit of prosecution for hit and run, what would be the incentive for a defendant not to run into a school bus of children and flee the scene, or mow into a parade of people and flee the scene?
So it's your argument that they have incentive to do that because they'll only be charged with one hit and run?
I think, yes, absolutely. If it's only one unit of prosecution for felony hit and run, then there would be no incentive not to just go all out. And
Aside from the underlying felonies that they'll be charged with?
Aside from the underlying felonies, yes, Your Honor.
I mean, that was going to be my question too, because here you have a defendant that is currently serving a life in prison sentence plus consecutive sentences for the assaults.
Right, Your Honor.
So, I mean, I think there's plenty of disincentive.
Absolutely, yes, but this needs to be taken just as seriously as the underlying felonies of assault with a deadly weapon with intent to kill. It's very dangerous to leave these people unattended in the parking lot without medical attention, and it could have meant the difference between life and death for some of these folks. They were very seriously injured. 3 of them were in the hospital for extended periods of time, and of course, 1 passed away as a result of being hit. And then moving on to the issues in Felton, there was intention for Ms. Felton to assist Ms. Watlington in this case. The elements of assault, the elements of accessory after the fact are that a felony was committed, the accused knew the person she received, relieved, or assisted was the person who committed the felony, and that the accused rendered assistance to the felon personally. And positioned in this posture of a motion to dismiss, there was evidence in a light most favorable to the state that warranted submitting these charges to the jury.
Can I just stop you for a moment? There seems to be 2 separate time periods. One is the time period where the actually fleeing the scene in the car, and that is the commission of the hit and run, correct?
Yes, Your Honor.
And the other is after that is over, or after they're all over. So I guess my question is, how wasn't Ms. Felton a principal in the act of fleeing the scene? How can she be an accessory after the fact to an ongoing felony?
Well, she provided assistance to Ms. Watlington after the felonies were committed.
But okay, so that's after running over the victims, correct?
Right.
I'm talking about the car ride, and the car ride itself is part of the ongoing hit and run conviction, correct?
It is.
So how can she be an accessory after the fact to the hit and run when she's what appears to be actually a principal to that?
Well, she did provide assistance to Ms. Watlington after she ran over these folks.
I understand that, but I'm asking about specifically the felony hit and run, correct?
Yes,
So the running part is part of the felony, correct?
it is.
The leaving the scene, and she actually left the scene, so she was doing what is the felony. How can you be both? The
Well, she
principal
didn't hit and run. She just left. She hopped in the car after the felony was completed, the assault with a deadly weapon.
But she can't provide assistance when she's actually doing it, correct? Seems like it's one or the other. You can't do both.
She didn't participate in the assault with a deadly weapon. She just left the scene and provided assistance afterwards in terms of leaving the car in the hiding spot, and she had the keys, which are the instrumentality to remove it if she had wanted to.
Is it the state's position that the actual accessory after the fact is the fact that they parked the car to try to conceal the car and that she took the keys and left the vehicle? Is that the reason the state says it's an accessory after the fact?
Yes, Your Honor, that's exactly the state's position on this case.
But nothing having to do with the actual hit
No.
of the people and the running afterwards. It's the fact that of the concealment of the vehicle.
That's right, Your Honor. That's the state's position. The trial court's denial of the motion to dismiss, he said that Felton willingly gets into the car with Watlington and allows and in fact condones Watlington to drive away and flee. Indeed, defendant Felton is participating with defendant Watlington as they flee the scene together in the murder weapon. The fact that the car was abandoned in such a manner is concealing the car. When defendant Felton took exclusive possession of the keys, she took control of the murder weapon and abandoned the car in a semi-secret location. Taking possession of the key and control of the car and fleeing when she had the ability and capacity to operate the car, she aided defendant Watlington in escaping arrest, detention, and punishment. And then whether defendant Felton simply took the keys on her own or was given the keys by co-defendant Watlington, nevertheless, she had evidence of the crime. And simply because the police caught her before she could dispose of them in some other way doesn't absolve defendant Felton of potentially being an accessory after the fact. So these all add up to her providing assistance to defendant Watlington after she fled the scene of the crime. And they were together at least an hour after the crime. They were found together on that sidewalk, not holding hands or anything, not right beside each other, but they were together when encountered by the police about an hour after the crimes.
Will you address the contention that if the entirety of the body-worn camera footage, I guess from Exhibit 87, is considered, that undermines the state's argument?
Well, the state said that the defendants were walking next to each other when the police encountered them, and that's not an improper argument. That is true. They were near each other. And it's reasonable to infer that they had been together for the hour before they were found after the crash. Officer Maughan said that the defendants were on the sidewalk along Westgate City near Doubletree Hotel about an hour after the crash, not far from each other, is what he said, and that co-defendant Watlington was a little bit further up. And this doesn't meet the standard for an improper closing argument that was not objected to. Prosecutors are given wide latitude. They can argue facts and reasonable inferences. And to warrant a new trial, the prosecutor's remarks must have perverted or contaminated the trial such that they rendered the proceedings fundamentally unfair. And we don't have that here. It was proper for the state to infer that the two were together on that sidewalk an hour after the crash and that they had been working together for that time period. And I'll be happy to answer any other questions about the other issues, should the court have any. Thank you.
Thank you. Sorry, 4 minutes. Go ahead. You have 3 minutes for rebuttal.
So may it please the court, I'm going to make a few quick points. First, I want to make a quick point with regard to the jury instructions on the assault charge and culpable negligence. And I think it's an important point that the case law on culpably negligent assault says that culpable negligence supplies the intent, not that it substitutes for intent. So when the jury instructions say intent, that intent can be supplied in a general way without, if you didn't apply the Jones rule, could be supplied by culpable negligence. And that's why the mere fact that the jury instructions say intent, intentionally strike, that intent could be supplied by culpable negligence. It's not that culpable negligence could be a substitute for that if a jury were instructed. Turning to the unit of prosecution issues, I think Judge Collins, one of your questions to the state hit on the same kind of idea, but Bellevue, United States, the seminal United States Supreme Court opinion on the rule of lenity, which our Supreme Court cited approvingly and applied in both Smith and Conley, makes it clear that when a legislature wants to create a multiple unit prosecution, the onus is on the legislature to clearly state that intent. And if that intent isn't clearly stated, then the rule of lenity applies, and we're not going to make multiple crimes out of a single transaction. That's what Bell says. That's what Smith applies from Bell. That's what Conley applies from Bell. And so here, the clearest way the legislature could have done that is just to say a person commits a separate crime of accessory after the fact for each felony committed by the principal, or in the hit and run context, an offense of hit and run is committed for each person who is hit. But they didn't, and they haven't. And as far as the state's argument on the hit and run about, well, there should be a separate charge for each victim, in State v. Smith, which is cited in the reply brief, back in 1964, our Supreme Court explained the gist of the offense is leaving. Lack of fault on the defendant's part isn't a defense. So it's not about causing the injuries. It's not about the gravamen, and the focus of the offense is on the leaving of the scene. And that's been since 1964, and our legislature has amended the statute many times, but they have not changed the gist of the statute. Again, the focus of that statute, it's a traffic statute, it's in Chapter 20, and it is impeding the investigation into a crash. So you can be wholly free of fault and yet commit this offense if you leave the scene. And so the fault of the driver for the accident is not what this offense is about. And so the state asks, well, how would it be charged? And the answer is it would be charged the same way as in the Valladares and Wilson cases, where they were charged in both of those cases, defendants were charged in a single count for a hit and leaving the scene of an accident which had injured, in one case it was 5, in one case it was 6 people, and they named each of the people individually in the indictment that were injured in one count. And that's how you would do it. And It's an example of charge in the conjunctive proving the disjunctive.
Can you tell me, give me the site for the Wilson case?
Hmm?
The site for the Wilson case, please.
I didn't bring it on my notes here. I have it done, but it's cited in the briefs.
In the brief.
It's
Okay,
in the
that's fine.
index. You'll have it there.
Okay,
And unless the court has any further questions, we will submit the case.
no, thank you. Thank you for your arguments, appreciate them. We'll take it under advisement. We will not go into recess, but we will take 5 minutes by the attorneys to change places or leave, allow students to come and go.